Hey folks, this is our third try at this. We've gotten off to some rough starts as far as getting this filmed. I promised you I was going to give you a video from part 5 dealing with parts of the Constitution, and this is from chapter 2, the Constitution chapter. We've talked a little bit about how to read the Constitution. We've talked a little bit about the length of the Constitution, how it's actually a very short and very broadly written document. When you think about it, we've talked a little bit about, it's important what it says, but it's also important what it doesn't say in terms of determining what kind of power the government can have. What we haven't talked about are the actual specific parts of the Constitution, and there's a few of these. I wanted to go ahead and get started really at the beginning today and get started with the preamble. You know, when you think about writing a paper, when you write a paper, you have an introduction, and the introduction basically says what you're going to tell them. You write your body of the paper and you tell them, and then you write your conclusion of the paper, and then effectively you tell them what you've told them. Now, the preamble is basically like the introduction to the paper. You're telling them what you're going to tell them. And if you go in the text, and if you jump over, this is actually on page 433, it actually has the preamble up there. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. Here's the thing. The preamble's the introduction, and they're basically giving you a hint of some of the things that are coming. But interestingly enough, people have sued at different points dealing with the Constitution. They've sued basically questioning, about this common defense or this general welfare. Is government really doing this? And the courts have always very consistently ruled that there is no legal significance to the preamble, which means you can sue on it as much as you want. You're not going to gain any rights out of it. It's just the introduction. Yes, it's part of the Constitution, but legal significance, no, really not so much. As you look at this, I've also included a link in there. And when you go into my MC, you'll notice that there's the second installment of Schoolhouse Rock dealing very specifically with the preamble. And it fits in some images as you watch it with this preamble. And somehow they managed to write a song that included all of the words to it. I'm assuming that they did a lot of drugs back in the 70s because they found a way to put together some Declaration of Independence songs and now preamble songs. But what I'd ask you to do is take a look at that, because maybe it will flesh out a little bit more what this common defense, general welfare, domestic tranquility means. Once you get through the preamble, there's actually what's considered the body of the United States Constitution. And the body of the United States Constitution is actually going to be Articles 1, Article 2, and Article 3. When you think about it, it's just like the First Amendment. They put religion and speech and press and so forth in that First Amendment. Why? Because it was most important. When they drafted the Constitution in Article 1, they put the legislature. And the argument was that we just fought a war to get away from an oppressive king. So let's create a government that is not going to create another oppressive executive. They created the legislative article to be first. And as you go through and you look at it, and again, I'll go back to the text on this one. You'll notice here, there's Article 1 right up there at the top dealing with the Constitution of the United States of America. And this is actually beginning on page 433. It continues onto page 434, onto 435, all the way through 436, and finally when we get to the top of 437, they get to Article 2. This is about 4 pages long. They wrote the legislative article in a very specific manner. They gave very specific powers and limitations. They gave things like, when you think about it, the right to coin money. They gave, when you think about it, the right to declare war. They gave, when you think about it, taxing and spending and things like this. All of these powers were actually included very, very specifically in there. Their sense is that they wanted to have a very clear legislative government, and although all 3 of these, Article 1, Article 2, Article 3, are supposed to be co-equal, the legislative branch was supposed to be the first amongst those equals. When you look at Article 2, it begins to change. They actually drafted Article 2 with George Washington in mind. And their argument, or their sense was that George Washington, he fought the Revolution. He's now considered the father of the country. We trust him to the point where we'll write this broadly, and we will allow George to basically come in and fill in some of the holes. And there are some things that even to this day were precedents that were set by George Washington, and they're done because George Washington had done them that way when he was in office. Now, when you look at Article 2, and I've already mentioned this to you, It starts up here at page 437. You see Article 2 very, very clearly there. Now, this is where it starts to get a little bit more interesting, because you'll notice over here it gets to page 438, and there, lo and behold, is Article 3. If the legislative article was actually 4 pages, and it's very, very long and specific, the executive article is much, much more general and much more broad. It's going to be determined, executive powers, they're going to be determined not just by what the Constitution says, but they're going to be determined by the person that holds the office and also the things ultimately that the country experiences. When you think about it, think about George W. and think about Bill Clinton. You know, George W. had the ability, let me rephrase that. George W. had the opportunity to be a great president. And when you think about it, I mean, 9/11 happened, there were hurricanes, there were a lot of things that happened to the United States that frankly were out of our control. Had George W. handled those things in a really strong manner, at least perceived as a really strong manner, I think it's safe to say he would have gone down as a great president. There is a perception out, though, that he did not handle them in a strong manner, and some people would argue he may have handled them very, very poorly in general. So with this in mind, W had the ability to be great, but it wasn't just because of the powers that were in the office, it was because of the circumstances. When you think about Bill Clinton, people seem to like Bill Clinton. They like him a lot more now than they did when he was president of the United States. When you look back at Bill Clinton's time in the White House, though, there weren't any wars, there wasn't any terrorism, there wasn't, everybody had money because the economy was so good. I mean, some people would argue that the biggest thing that happened during the Clinton years was actually Monica, and that's really not something that's going to get you considered to be a great president. Notoriety, yes, but certainly not necessarily respect or appreciation. When you think about it, Bill Clinton is probably never going to go down as a great president, just like George W. Not because the Clinton years weren't good years, but because Clinton and the White House didn't have things to solve. George W. had things to solve and didn't do it. He's not going to go down as great. Bill Clinton didn't have things to solve, and ultimately he didn't have anything to do, at least to some of the degree of significance of some of the other great presidents. He's not going to be considered great, I don't think, in history also. When you consider the powers in the executive branch, it mentions things like, oh golly, the commander-in-chief power. It mentions things like take care that laws be faithfully executed and things like this. We don't really know what these mean, and we're going to talk about these more in the executive chapter. But if you have the ability to declare war, you know what? We know what that means. If you have the ability to coin money, we know what that means. If you have the ability to spend, the tax and spend power, we know what that means. But take care that laws be faithfully executed, that's a lot drier. And like I said, that's going to be something that's going to be filled in first by the person that has the office, and second, when you think about it, by the events that the office faces when they're in office. Now, the third article is actually Article 3, and this is dealing with the courts. And when you take a look here, here's page 438, there's Article 3, plain as day. And then when you move over to page 439, there is Article 4. So if Article 1 was about 4 pages, Article 2 maybe about a page and a half or 2 pages, Article 3 is not even a full page long. Article 3 created one Supreme Court and then as many other courts as Congress deemed necessary. And to be honest with you, I think you can argue that maybe they were just tired of drafting the Constitution. Maybe they really weren't sure what they were supposed to do with this, court system, because this was very different than the Articles of Confederation. But the bottom line is that this is the shortest of all. And if you think about it, if legislature is supposed to be 1, executive is 2, maybe it makes sense that Article 3, the courts, the least co-equal of the 3, would be the one that would have the shortest article. Again, we're going to talk about all of these when we get into the specific chapters after spring break. Now, to kind of jump back into the actual outline itself, when you notice up here, you'll see Article 4. And Article 4 is actually dealing with the full faith and credit clause. I'm guessing that a lot of you have driver's licenses, and I'm guessing that a lot of you have a Maryland driver's licenses. And it makes sense that you should be able to drive in Maryland with a Maryland driver's license. But can you drive in Pennsylvania? Can you drive in Delaware? Can you drive in Iowa? Can you drive in California? Well, the answer to all of this is yes. But the question really is, why is it that you don't need a different state driver's license every time you go to a new state to drive? That's interesting, right? Or maybe not. Well, for our purposes with Article 4, it's the full faith and credit clause. The full faith and credit clause basically says that if you have a valid state document from one state, this is going to be recognized in other states as well. So if you've got a Maryland driver's license and it's not fake and it's valid, it's up to date, this kind of a thing, it's not expired, you're going to be able to legally drive everywhere. Now, if you move someplace else, you're going to need to get a driver's license from that state. But if you're just passing through, you don't. I mean, it makes sense for commerce, for travel, all sorts of things. But again, the key is that it's a valid state document. You'll notice up here not only driver's license, but crime. Let's say that you break out of jail and you're wanted in Maryland. Let's say that you break out of jail, you go to New Mexico, and ultimately you're caught speeding in New Mexico. And when they run your information, they realize that you're actually wanted in the fine state of Maryland. Believe it or not, Full Faith and Credit says is that if you've got that outstanding warrant, if you've got this outstanding legal paperwork, valid legal paperwork from Maryland, then in fact New Mexico is going to have to send you back. Because again, we're basically honoring that kind of a thing. When you think about it, marriage is another good example. You know, if Adam and Eve got married in Maryland and then they decided to move to any number of the states in the United States, they're still going to be legally married there, because marriage is a contract. It's also a state document when you think about it, a marriage license. As long as you receive a validly passed, a validly accepted, ratified, however you want to look at it, marriage license, then in fact it's going to be recognized everywhere. Now where this gets squirrely though is gay marriage. And when you think about it, Adam and Steve could conceivably get married in Massachusetts. I mean, gay marriage is legal there. If they move down to North Carolina, it's not. Well, that would seem to suggest that the Full Faith and Credit Clause should force them to be allowed to be married down in North Carolina, but the government has not gone quite that far yet. We've talked about the idea of the Equal Rights Amendment maybe creating gay marriage rights. That didn't pass. This Article 4 has been in the Constitution for a long time, since the beginning. You would think that maybe this would work, and the folks in the feds have not gone quite this far yet either, out of respect for states' rights. Article 5. One of the nice things to know about the Founding Fathers is that they knew enough to know that they didn't know everything. They knew enough to know that they didn't know everything. So they set in Article 5 the amendment process. And the idea behind the amendment process, very simply, is this. They set together a process so that they could add amendments to the United States Constitution because they recognized that situations would change, powers would change, people would change, the world would change, all sorts of things. Granted, they wrote it broadly so that it could adjust oftentimes by itself, but there would be a need for a process. And if you turn in the chapter, and I'll go ahead and go back at this point to the document cam here. If you turn in the chapter and you go back to, I believe it's page 32, it is, page 32, you'll notice down here that there is a couple of boxes, and it says methods for proposing and ratifying constitutional amendments. We talked about this very briefly the other night. In order to propose a constitutional amendment, you've got to have a 2/3 vote by both the House and the Senate. You've got to have a 2/3 vote by both the House and the Senate. And when you think about it, oftentimes that's very difficult to do. Because one party may very well get a majority, that's fine, but 2/3 is actually a fairly significant majority, which means that if the Democrats have the majority in the Senate, they're going to need some Republicans to join with them to propose a constitutional amendment. And likewise, if the Republicans have control of the House, they're going to need some Democrats to join with them in order to propose this amendment. Now let me stress to you, we're just talking about proposing it. They're suggesting this amendment at this point. So you get a 2/3 vote of the House, a 2/3 vote of the Senate, and they now can propose this amendment to the people, to the states, to the country at large. Which actually is going to take us to the second box, ratification. And I'll just read this off so that there's no confusion on this. The fraction is 3/4 this time, and it says approval by state legislators of 3/4 of the states, or approval by ratifying conventions in 3/4 of the states. Key thing here is it takes 2/3 to propose, takes 3/4 to ratify. And in other words, that basically means that we're talking 38 out of the 50 states. When we talked about the Equal Rights Amendment, I think they had gotten up to 34 or 35. They ultimately extended deadlines, but they never got it passed. Sometimes it's very difficult, and you're talking about 5, 10 years easy a decade, to be honest with you, to try and make sure that these things are going to pass. And it doesn't work that often. There have only been 27 amendments that have been offered in the United States history to the Constitution. The Bill of Rights were basically added almost immediately, so you could maybe even argue that there have only been 17. And our last amendment was in 1992, which means we're probably overdue for number 28. To give you a sense, though, for our purposes, and again, going back to the chart on this, it basically says here, the amendment process, some specific amendments. And let me give you a couple things to think about as far as that's concerned. And again, I'll just move over, and this is actually going to be on page 33. When you think about it, some folks have a tendency of thinking that it is actually English is the national language. There have been amendments proposed to suggest this, and it's never actually passed. There is no national language in the United States. Some people have questioned whether or not the United States flag is legal to be burned. In fact, it is. People have suggested amendments that would deny the ability to burn the American flag. These amendments have actually been very consistently voted down. Flag burning is considered speech. I mean, when you think about it, if you see somebody and they're burning a flag, it's pretty apparent that they're sending a message, and it's pretty apparent you know what that message is. So the sense of it is that this is actually considered free speech under the First Amendment. It is protected. So 2/3 and 3/4 are the key here. There have only been 27 of these, and frankly, we're overdue for the next one. To get into Article 6, and again, very brief, two pieces to Article 6 that are actually very, very important. One is the Supremacy Clause, and two is the Religious Oath. According to the Supremacy Clause, basically this is saying that the Constitution of the United States is going to be the supreme law of the land. And if you remember back to the Articles, it was the states that ran the show under the Articles. If you remember, it took a unanimous vote to pass a law. One state could vote no, and they could kill the whole program. Well, under the Supremacy Clause, basically what they're saying here is that if states have laws that contradict the Constitution, the federal Constitution wins. And this was really a big piece in terms of establishing federal power over the states. In the beginning, the states were the ones that basically ran the show. The federal government was down here. Well, over the course of time, if you look at today, now it's the federal government that is running the show, and in fact, it's the states that are down here. In large measure, it's because of the Supremacy Clause. The other thing that's in there is the idea that you shall not be required to take a religious oath. You shall not be required to take a religious oath in order to obtain office in the United States. And basically the deal here is that this is really, you know, we talk about First Amendment, talk about freedom of religion and free exercise and Congress shall make no law and all these other things. And this is all true, but that was an amendment. In Article 6, this no religious test provision is actually one of the few places where they actually protect religion very openly in the United States, the original United States Constitution. So keep that in mind. This was passed from the beginning. The First Amendment was only added later on. So these two provisions, the religious oath part and the Supremacy Clause, are Article 6. And then last part up here is Article 7, and we've addressed this, ratification. It took 9/13 of the states in order to ratify the United States Constitution. And if you remember, it was 9 states specifically because they knew that they had 9 states that would say yes on this. So as you look at this, this is actually the actual United States Constitution. There's only a preamble and 7 articles. Now, the Bill of Rights is the other piece, and I'll mention this just very, very briefly, because we're going to talk about this later on and really throughout the class. The Bill of Rights are the first 10 amendments to the United States Constitution. And those 4 states in the beginning, if you remember, that had questions about whether or not they were going to ratify the Constitution, those 4 states demanded protection from the federal government being able to step on their rights. And the protection came in the form of the Bill of Rights. Did all 13 of the states originally, or eventually I should say, ratify the Constitution? Yeah, they did, but they had to get the Bill of Rights first, and in fact they got it after the Constitution was ratified. So that's really what that is. The Bill of Rights is only the first 10 amendments. So when we talk about freedom of speech or freedom of religion, when we talk about the right to bear arms, when we talk about no unreasonable searches and seizures, or no self-incrimination, or no cruel and unusual punishment, all of these are amendments that are basically kind of smattered through those Bill of Rights. I think this really sums up this section. If you've got any questions, please don't hesitate to give me a holler. But for exam purposes, just make sure that you can link the section or the article of the Constitution with some of the different purposes that I've mentioned.